This is a video about the different stages of a lawsuit. Lawsuits are far more complicated than most people realize, and people who are not lawyers are often disappointed and disillusioned after being involved in the justice system. Most people who are accused, whether it be accused of a crime, or accused of negligence, or accused of something else, even something minor, are often surprised that judges will not dismiss a case simply because the evidence is weak. And most people who make accusations, civil and criminal accusations, are often surprised that defendants are given many chances to challenge the accusations, and that defendants enjoy a presumption of innocence or presumption of non-liability until the very end. Let's focus on civil suits, which can be said to have 9 stages. The stages are 1. Filing a petition, 2. Service of process, and process is sometimes called citation or summons. 3. Answer. 4. Discovery. 5. Motions. 6. Trial. 7. Judgment. 8. Appeal. And 9. Collections. There is a lot that goes into a lawsuit before it's filed, but it is not a lawsuit until it is filed with a court. The person filing a lawsuit is usually called plaintiff, and the person being sued is usually called defendant or respondent. When a lawsuit is filed, a petition must be delivered to the clerk of the court. For example, McLennan County has 5 district courts, and all 5 courts share a district clerk. When a petition is taken to the district clerk, the lawsuit will be assigned to one of the 5 courts according to a system the 5 district judges agreed was fair to keep the workload even between the courts and to move all the cases efficiently. In McLennan County, 2 of the district courts handle nothing but criminal cases, so all the civil suits go to the other 3 district courts. Filing a petition, delivering it to the clerk, may sound complicated and intimidating for some people. A petition is simply a written description of the lawsuit, what it is, what it's about, who it's against, and what the plaintiff is seeking. The law requires the petition to specify certain things, but the requirements, surprisingly, are flexible. Mainly, the petition must allege the elements of the claim and specify the relief being sought using words a reasonable person could understand. For example, if the lawsuit is based on a car wreck, the petition should give the defendant fair notice of which car accident it was and why it is supposedly the defendant's fault. If negligence is being claimed, the petition should hit on each element of negligence: duty, breach, cause, and harm. Specific facts are not always required, but are usually stated, such as the following. John Dunn failed to look for cross traffic as a reasonably prudent person would look before proceeding into the intersection. John Dunn was traveling at an excessive speed for the circumstances. As mentioned, the law requires the plaintiff to state what relief is being sought. The plaintiff is not required to specify the money to the penny, but the plaintiff is required to give a range, such as more than $50,000. Also, if the plaintiff wants a court order for something to be done or not done, then the plaintiff must specify that. In a child custody case, the plaintiff might say they want standard visitation. If it's the kind of a nuisance case that involves burning trash, it might ask for injunctive relief prohibiting burning of trash. Another example, delivery of the goods, if it is that kind of breach of contract or conversion case. Find the respondent in contempt of court and sentence him to jail. Enter a finding that the land is owned by plaintiff and that plaintiff should have immediate possession. In the last example, issue an order instructing Bank of America to freeze the account. Once the lawsuit is filed, the defendant needs to be notified of the lawsuit. The most common and best way to give the defendant notice is to have the court clerk issue a citation or process, or sometimes called a summons, and have a constable or process server hand deliver it to the defendant. There are other methods allowed in special circumstances, but the law prefers hand delivery by a person who is hired for that one purpose. However it is done, the law requires the defendant to get notice of the lawsuit, usually with a copy of the petition. Court rules require it, statutes require it, but most importantly, the U.S. Constitution requires notice as a part of due process, which is discussed in a separate video. Here are some examples of citations. If you can read them, then you can see the citations say, "You have been sued," and the citations specify that an answer must be filed. Once the defendant receives notice, he has a little time to hire a lawyer and prepare a response to the petition. Filing a response is step 3, and the time is usually about 21 days. But however long it is, or however the defendant uses the time, the defendant must file a response to the petition before the time is up. The response is often called an answer or an appearance, but an answer is more accurate because the answer has to state why the plaintiff should lose. The answer is the defendant's response to the petition, so it might include just a denial, or it might state defenses such as a self-defense argument, or it might include a countersuit, although technically a countersuit is different than an answer. If an answer is not filed in time, the defendant loses the lawsuit by default. Once the lawsuit has an official statement from each side, that is a petition and an answer, then the lawsuit can proceed to steps 4 and 5, which are discovery and motions. And just a note here, lawsuits can have more than 2 people involved. Conceivably, lawsuits could have thousands of people involved. And conceivably, not all of them will get notice at the same time. Not all of them will file answers at the same time. And so sometimes discovery and motions start without some of the parties involved. The steps 4 and 5, discovery and motions, usually proceed together, and the purposes in each are very similar. Discovery is the process by which each side gets to learn of the theories and evidence from the other side. Motions are the process by which each side gets rulings from the judge on small disputes. The ultimate purpose of discovery and motions are to narrow the issues. For example, in a breach of contract case in which one side claims money was never paid and the other side claims the money was paid, each side will use discovery to see each other's payment records and receipts. And one side might file a motion for summary judgment, asking the judge to conclusively decide the money was or was not paid. A motion for summary judgment is one of the most common ways a party in a lawsuit will try to bring the lawsuit to a faster end. If the judge grants a motion for summary judgment on a conclusive issue, then one side or the other wins before a complete trial is necessary. However, judges deny more motions for summary judgment than they grant. The next step is trial. Trial can be with a jury or not, but every trial has a fact finder, which is a person or group of people who decide what the facts are. Example: in a negligence lawsuit, the fact finder will decide there was duty, breach, cause, and harm, and the fact finder will decide how much money is necessary to make the plaintiff whole again. That is, how much is necessary to put the plaintiff in the position they would be if there were never any negligence. You may say, "I have never heard of a fact finder before," and that is because in movies and on TV, the jury is usually the fact finder. But if there is no jury, then the judge is the fact finder. And when I say that the jury will decide if there was duty, breach, cause, and harm, the questions that are put to the jury aren't quite worded that way. The questions to the jury will be, do you find that on such and such a date, the collision in question was proximately caused by the negligence of defendant driver? So rather than say duty and breach, the question to the jury will just ask about negligence. And then it will say, was there proximate cause? And then the next question after that will be, well, how much should be paid? Which is a question about harm. After trial, whether with a jury or without, the judge will take the facts and apply the law and come up with a written judgment. In a contested case, sometimes the parties can spend a lot of time and money arguing about the judgment. Once a final judgment is signed in a case, then the losing party or parties can appeal. Sometimes nobody is happy with the judgment, and everybody appeals. There are two kinds of appeal, de novo and not de novo. De novo is a Latin phrase meaning from the beginning. If the appeal is de novo, then the higher judge can redo everything. The higher judge starts all over from the beginning, essentially. Appeals to a county court, or to a county court at law, or to a district court are de novo. Appeals from county court at law, or district court are generally not de novo. Those appeals go to a court of appeals, and those appeals are not usually de novo, but some issues can be treated de novo by the Court of Appeals. Usually a Court of Appeals does not start from the beginning. Instead, a Court of Appeals gives a lot of deference to the judge below and will support decisions from below or affirm decisions from below unless the decisions were obviously wrong. The phrase used by courts of appeals for reversing a decision below is clear abuse of discretion. Without a clear abuse of discretion, the judgments from below will be affirmed on appeal. And statistically, about 90% of all appeals lose in the courts of appeal. Of course, after the courts of appeal, a civil case could go to the Texas Supreme Court. But the Texas Supreme Court does not accept most cases. In fact, both of Texas' highest courts refuse more cases than they take. After appeal, if there is a final judgment still standing, then the last step is enforcement or collections. At this point, the judgment is final, but it is just a piece of paper signed by a judge. In order to collect money, the person claiming the money will need to get a sheriff's deputy to act in some way, such as seizing a bank account or auctioning off some property. There are different ways of doing this depending on what is being taken exactly. One way to get money is to have the judgment executed. Sometimes this is called levy execution. It means the sheriff goes to the defendant's home or business and starts taking things that can be auctioned, and then auctioning them for cold, hard cash. If there is a specific item to be gotten, such as a boat or house or bank account, then the act of seizing it is called attachment. Texas also allows liens on real estate. A real estate lien is accomplished by filing what's called an abstract of judgment with the county clerk, where the real estate is located. That's like getting a hook in the real estate. So if it's ever sold, then a portion of the money is supposed to go to pay off the judgment that has been abstracted. Garnishment is the act of taking somebody's paycheck. Texas does not allow garnishment except for child support. Now, Texas law protects individuals from collections to some extent. As already mentioned, garnishment is not allowed except for child support. And when I say collections, I'm talking about collections after a final judgment. After all appeals have been exhausted and there's still a judgment, then it's going to collections. I'm not talking about the kind of collections where a credit card company is just calling and harassing somebody. As already mentioned, garnishment is not allowed except for child support. But also, every individual is allowed to keep certain property no matter how much money they owe. For example, every person is allowed to keep the house they live in, and at least one car, and tools for work, and clothes to wear. In fact, most people are considered judgment-proof, which means no matter how much money they owe, nothing can be taken from them. This is either because the law protects so much property, or because most people only own the essentials. Let's spend a little more time on liens. If a person owes money on their house, the bank almost always, if it's a smart bank, has a lien on the house, or a lien, same thing, or a deed of trust. There are two ways it can work, but both ways mean the bank can take the house if the person does not pay what they owe. It's the same for a car. When a person borrows money to buy a car, the financing company gets a lien on the car. Car title loans are similar. You might use the money from a car title loan to pay your electric bill, But if you do not repay the money to the loan people, they come and take your car. These kind of liens must be in writing and agreed to by the person who borrows the money. Liens affect execution. And we're going back to collections to talk about collections again. Liens affect execution a couple of ways. First, the law that protects every person from losing their house, their car, their work tools, etc., does not apply if the bank has a lien. If the bank has a lien, the bank can take the property that they have a lien on, because technically it's partly the bank's property too. So if the bank has a lien on a house, and the house loan is not paid, the bank can come and take the house. But I'm not saying the bank can take the car and the work tools, because the bank won't have a lien on the car and the work tools. The bank only has a lien on the house. And it's partly the bank's house because they have a lien on it. So they come and take it. Second, if somebody without a lien executes on a house, a boat, a plane, or whatever, somebody else's lien does not disappear. For example, O.J. Simpson murdered his ex-wife. The ex-wife's family sued O.J. Simpson and got a judgment against O.J. for $33.5 million. If somebody executes the judgment on O.J.'s motorcycle, they might get it. But if O.J. Simpson owes money on the motorcycle, the lien does not just disappear. Nobody can make a lien disappear except by paying what is owed. Let's say O.J. owes $28,000 on the motorcycle, and let's say the motorcycle is worth $28,500. Then anybody who executes on the motorcycle is only going to get $500 at best. In that example, even though O.J. owns a motorbike worth $28,500, he is still fairly judgment-proof. Finally, this is a good time to mention alternatives to court. Mediation and arbitration are the two biggest alternatives to court. They are generally faster and cheaper, and to a degree they are more reliable. Arbitration is binding from the start. Mediation is binding only after the parties sign the agreement. Both mediation and arbitration are options at any stage of a lawsuit. Some people mediate before any lawsuit is filed. Some contracts require arbitration before a lawsuit is filed. And they both remain options until the last stage, collections.